Mr. Bernie Crean ran two pubs in Staines, the Cock Inn and the Phoenix, which were across the road from one another. The pubs were owned by Courage, the brewer, which owned a sizable proportion of pubs in the country. And Mr. Crean's lease required him to buy most of his beer from Courage and to sell it at a price which was substantially higher than the price at which Courage sold its beers to the independent pubs. Now, this made things very difficult for Mr. Crean. He had wanted to attract a younger clientele to the Phoenix, and he laid on entertainment there to try and attract them. And his plan was to make the Cock Inn attractive to older pubgoers, and so Mrs. Crean cooked and provided food. But despite the best efforts of the couple, the high beer prices drove customers away, and Mr. Crean was driven out of business less than 2 years after entering into the leases. David Vaughan QC represented Mr. Crean over a period of some 13 years. The origins of the claim were an action against Mr. Crean by Courage for about £15,000 in respect of beer which they had delivered to the pubs before they went out of business and which he couldn't use and pay for. But Mr. Crean counterclaimed for damages for breach of what was then Article 85 of the treaty, so that dates it, alleging that the beer tie arrangement satisfied the de limitis test, namely that it was difficult for competitors to enter the market or increase their market share for the distribution of beer, and that Courage's network of beer ties made a significant contribution to that sealing off, that market foreclosure effect. David Vaughan's efforts on behalf of Mr. Crean involved numerous hearings before the domestic courts and the European courts. In fact, I discovered in preparing for this lecture that the Courage and Crean saga has its own Wikipedia page. The European Court's judgment on a reference from the Court of Appeal on the first of two occasions that the case came before the Court of Appeal was of seminal importance. It established for the first time that damages are indeed available against private parties who have breached the EU competition rules, and held that this follows from the EU law principle of effectiveness. And until the ECJ judgment in 2001, this hadn't been established before. So, of course, damages have been available against the state, but now, and as a direct result of that judgment, damages claims in private actions, in competitional actions, have, of course, mushroomed and are seen as a critical part of competition enforcement. And what happened after the ECJ judgment is of relevance to the theme of my lecture this evening. Mr. Crean then pursued his claim for damages before Mr. Justice Park in the Chancery Division, and although the Courage beer ties had been before the European Commission, the Commission had for various reasons not reached a decision in relation to them, a decision either way. But Mr. Crean was armed with other decisions taken by the European Commission in relation to materially identical leases by Whitbread, Bass and Scottish and Newcastle, each of which was similarly to Courage, a major landlord of pubs in the UK at the relevant time. And in each of those cases, the Commission had found that the de limitis conditions were satisfied and that the beer ties fell within Article 101(1) of the treaty. The trial was heard by Mr. Justice Park and lasted a full 29 days. There were 32 witnesses of fact, 18 for Mr. Crean and 14 for Entrepreneur, who Courage then became. No fewer than 8 experts also gave evidence on competition economics, on valuation, and on the brewing and licensed premises business. The key issues before the court were whether the two de limitis conditions were met, such that the beer ties were caught by Article 101(1), if so, whether the block exemption applied, and if it did not, whether the infringement had caused Mr. Crean to suffer loss, and if so, how much loss. In his judgment, Mr. Justice Park found that the first de limitis condition was not satisfied, but in all other respects, he would have found in favour of Mr. Crean. So in particular, the judge accepted that if he had been wrong to find that the beer ties fell outside Article 101(1), then he would have found that they didn't benefit from the block exemption and that the infringements had caused Mr. Crean to suffer loss amounting to nearly £1.5 million. Mr. Crean appealed, the Court of Appeal upheld Mr. Crean's appeal on the ground that the principle of sincere cooperation required the trial judge to give the Commission's decisions in Whitbread, etc., much greater deference than he actually did. Essentially, the Court of Appeal found that it wasn't open to Entrepreneur to contend that those decisions were wrong, and it determined that Mr. Crean was entitled to damages. And so its decision created another legal landmark to add to the others on David Vaughan's CV. Mr. Crean was the first claimant to be awarded damages by the English courts for breach of competition law. But the award of damages was short-lived because the House of Lords stepped in to reverse the Court of Appeal's decision and restore the order of Mr. Justice Park. The House of Lords found that Mr. Justice Park had not been required by EU law to accept the Commission's assessment of the delimitus point, because that assessment was not contained in any decision binding on Entrepreneur. Mr. Justice Park, the House of Lords held, had therefore done precisely the right thing in considering the matter for himself on the basis of all the evidence before him. Now, why is any of this relevant to the question of how Brexit will affect the enforcement of competition law? It's relevant because it demonstrates that differences already exist between the way in which English courts enforce competition law and the way in which the European Commission and European courts do so, and that these are already apt to yield different results. The Commission, in its Whitbread decision, based its conclusion on the delimitus test on documents before it, including a report of the Monopolies and Mergers Commission and data from the Brewers and Licensed Retailers Association. That evidence and the Commission's reasoning in its decision was scrutinised by Mr. Justice Park, but he found that the UK market was not foreclosed on the basis of what he heard from the witnesses before him. As the judge said at paragraph 166 of his judgment, in contrast to the lack of specific evidence from witnesses called on behalf of Mr. Crean, there was a lot of evidence from witnesses for Entrepreneur, both expert witnesses and witnesses of fact, who had real hands-on practical experience and knowledge of the events which actually took place in the United Kingdom market. So Crean is a perfect illustration of how the seeds for the divergent application of competition law in the EU and in the UK already exist, and indeed already pre-Brexit sometimes lead to divergent results. And these seeds or sources of divergence are inherent in our differing legal traditions. Take a decision of the Commission and a similar decision of the CMA and contrast how they're handled on appeal. An appeal before the General Court will often take a day or less. The longest hearings in the most complex cases before the General Court might be listed for 4 days, as the hearing was in the Intel case. The General Court will almost never hear live evidence. The focus will be on the documentary material. Appeals before the Competition Appeal Tribunal, by contrast, may be listed for several weeks and are almost bound to involve both factual and expert evidence. Even where there's been a decision of the CMA, the process is the same or very similar to that followed by Mr. Justice Park and Crean. Now, continuing with my pub crawl, I want to move from the Cock Inn in Staines to the Horse and Groom in Marylebone. It was in the Horse and Groom that Mr. Mike Ashley, owner of Newcastle United FC and majority shareholder in Sports Direct, was drinking one evening with a group of people which included Mr. Geoffrey Blue, a consultant hired by Sports Direct. Mr. Blue claimed that during this drinking session, Mr. Ashley verbally agreed to pay him a £15 million bonus if he could get the value of Sports Direct shares up to £8. Mr. Ashley couldn't remember this conversation, but said if it did happen, it was just drunken banter. The court heard how Mr. Ashley allegedly held regular senior management meetings during lock-ins at the Green Dragon pub in Alfreton near Sports Direct's warehouse. During other meetings, Mr. Ashley is alleged to have expressed his boredom and frustration with city figures by lying under the table to have a nap. On the occasion in question, Mr. Ashley was alleged to have challenged a young Polish analyst to a drinking competition in which they drank a dozen pints followed by vodka chasers. The rules of the drinking game were that whoever left the room first was to be declared the loser. After approximately 12 pints and chasers, Pavel Pavlovsky apologised profusely and had to excuse himself, Mr. Blue stated in his witness statement. Mr. Ashley then vomited into the fireplace located in the centre of the bar to huge applause from his senior management team. The judgment doesn't record what became of young Mr. Pavel Pavlovsky. This attractive claim came before Mr. Justice Leggett in the Commercial Court. He dismissed the claim, concluding that the fact that Mr. Blue has since convinced himself that the offer was a serious one and that a legally binding agreement was made shows only that the human capacity for wishful thinking knows few bounds. This was a case in which the alleged agreement was entirely undocumented, and so the claim turned on the judge's findings about the conversations that had actually taken place in the pub. Referring back to his judgment in Guestman and Credit Suisse, the judge made some very interesting observations about the fallibility of human memory, including the psychological research that demonstrates that memories are fluid and malleable, that memory is particularly unreliable when it comes to recalling past beliefs, and that there's a powerful tendency for people to remember past events concerning themselves in a self-enhancing light. Well, who can honestly say they haven't done that? It was in light of such research that Mr. Justice Leggett arrived at the striking conclusion in Guestman, para 22, that the best approach for a judge to adopt in the trial of a commercial case is to place little, if any, reliance on witness recollections of what was said in meetings and conversations, and to base factual findings on inferences drawn from documentary evidence and from known or probable facts. Mr. Justice Leggett's observations have attracted support from other judges and may signal the beginning of a different judicial approach to witness evidence, indeed one that moves closer perhaps to the approach of the Commission and European courts. I'll return to this, but as matters stand, the judicial process in Luxembourg is very different to that in the UK. Take the ongoing paroxetine pay-for-delay litigation, in which both the Commission and the CMA investigated and fined pharmaceutical companies in respect of agreements which settled patent litigation between them, and also provided for the transfer of value from the originator companies to the generic companies and the agreement of those generic companies to stay out of the market with their rival much cheaper drugs. The Commission and the CMA both carried out investigations into very similar arrangements. The Commission made decisions in 5 cases, which I'll refer to collectively as the Lundbeck cases, but which concerned 5 separate sets of agreements between different originator and generic pharmaceutical companies. The CMA reached its decision in the paroxetine case. These investigations were, of course, carried out in the context of the present legal regime of cooperation, including information sharing arrangements between the Commission and national competition authorities such as the CMA. Indeed, the investigation started because the Commission referred the paroxetine file to the CMA to investigate. The respective decisions are similar in approach and in scope and reach consistent conclusions. And they each imposed substantial fines on the companies concerned. But think about the procedure that happened next. Lundbeck appealed to the General Court. There was an exchange of pleadings in which Lundbeck advanced several grounds of appeal and took issue with the Commission's analysis of the law and assessment of the evidence. There was a hearing that lasted 1 day in Luxembourg, at which there was no live evidence. In contrast, GSK and the 4 generic companies who were the addressees of the CMA's paroxetine decision appealed to the Competition Appeal Tribunal. Their appeals were accompanied by factual and expert evidence, not all of which had been put before the CMA during the administrative procedure. There was then a trial lasting no fewer than 5 weeks in the Competition Appeal Tribunal in the spring of this year, at which the tribunal heard from several factual and expert witnesses. GSK's main factual witness was cross-examined by the CMA for nearly 2 days. 4 expert economists gave evidence. The tribunal hot-tubbed their evidence. In fact, there were 2 hot tubs, the first on the economic aspects of the pay-for-delay theory of harm, and the second on market definition for the purposes of Article 102. Counsel were permitted to ask supplemental questions by way of cross-examination at the end of the hot tub sessions. This all took several days. The expert economist called by the CMA, Professor Carl Shapiro, has been highly influential in this area over a considerable period of time. And his pay for delay theory, on which he's written multiple papers, has undoubtedly influenced not only the US courts but also the CMA and the European Commission. And the CAT had the opportunity in this case to ask him a series of detailed questions about his theory and its application to the case, and importantly to hear the competing views and criticisms of the expert economists called by the appellants, and then again in turn Professor Shapiro's response to those criticisms. The General Court, of course, didn't have anything like that in its day-long hearing. Now, I leave aside for the moment the question, which is contentious between the parties, of the extent to which the CAT, the Competition Appeal Tribunal, is bound to follow the judgments of the European Court in the Lundbeck cases. But the short point I wish to make is this. Decisions by the Commission on the one hand and by the CMA on the other, even if very similar to each other, may end up having entirely different fates on appeal, given the very different judicial process to which they'll be subject. And what I'd like to do now is identify what these key differences in judicial process are, and explain how even now, pre-Brexit, they can lead to competition enforcement that diverges as between the UK on the one hand and Brussels and Luxembourg on the other. I'll then consider how these differences are likely to assume greater importance after Brexit, and finally I'll make some observations or ask some questions about what that might mean in practice for competition enforcement going forwards. So, key differences. Comparing the approaches of the English and European courts, I'd like to focus on these three differences. First of all, substantive law. Secondly, standard of review. And thirdly, treatment of evidence. In terms of substantive law, the Korean case, of course, was a case in which an English court reached a different conclusion to the Commission as to the application of Article 1011, but the different conclusion it reached didn't turn on a different view as to the substantive law, but more a different view as to how the law applied to the facts. But there are under the current regime, plainly constraints on the circumstances in which the English courts can take a different view of the law, but it sometimes does happen, and an example of that is provided by the judgment of the Privy Council in Carter Holt Harvey Building Products Group against the Commerce Commission, which was an appeal from the Court of Appeal of New Zealand. And the question before the Privy Council was whether the company concerned had abused its dominant position by price cutting and excluding competitors. By a majority, and having considered EU case law as well as case law from other jurisdictions, including notably Australia, the Privy Council allowed the appeal and found that the company had not abused its dominant position, saying this at paragraph 66 of its judgment. It said, "There's an important issue of principle, and the extent to which competition law should inhibit price cutting by dominant firms is known to be a difficult area. The public interest lies in preserving the ability of firms to compete with each other in a competitive market, on price as well as on quality. It's not well served if a firm which has a dominant position in the market is penalised for cutting prices, when that same conduct, if undertaken in the same circumstances by a firm which was not dominant, would not be. The facts need to be scrutinised with particular care to ensure this doesn't happen." Now, this, in my view, amounts to a statement that the rule in AXO, and by implication all the other Article 102 cases in which dominant firms are penalised for conduct that could equally have been done by non-dominant firms, operates against the public interest. So plainly in that case, because it was an appeal from the New Zealand courts, the Privy Council took a different view on what the law is or what the law should be. What of the standard of review on appeal? An action for annulment before the General Court takes the form of a review of the Commission decision, whereas an appeal before the CAT against a decision taken by the Competition and Markets Authority under the Competition Act is a full merits appeal. As I see it, this translates into two main differences in practice. The first relates to the extent to which an appellant before the General Court can introduce new arguments or evidence that were not before the Commission during the administrative procedure. Given that the General Court is carrying out a review of the Commission decision, there are some constraints on the ability of appellants to introduce new arguments and evidence at the appeal stage. And we see in AstraZeneca, for example, the General Court pointing out that although the Commission's required to take into account a possible objective justification for conduct which might constitute otherwise an abuse of a dominant position, it is necessary for the undertaking concerned to raise that objective justification during the administrative procedure and to put forward arguments and evidence in support at that stage. By contrast, appellants before the Competition Appeal Tribunal can in principle advance entirely new arguments and evidence on appeal and are not restricted to the arguments they advance before the CMA. It's true that the Tribunal's rules have now been amended so as to permit objection to be made to evidence, including new evidence, but the simple fact of not having adduced it during the court of the administrative procedure is not likely in itself to be sufficient to lead to its exclusion. This creates a certain imbalance in favour of the appellant. The CMA can, of course, adduce evidence to rebut the new evidence adduced by an appellant, but it's still defending its decision, and it can't simply advance a new factual basis for that decision at the appeal stage. Second aspect of the standard of review that I wish to highlight is the different approach of the General Court and the Competition Appeal Tribunal to matters of economic assessment. An appellant in Luxembourg must demonstrate that the Commission has made a manifest error of assessment in order to succeed, whereas before the CAT it's all up for grabs again on a merits appeal. What does this mean in practice? Well, market definition is a matter for economic assessment. Let's take as an example the issue of market definition that is live in the paroxetine case. And the interesting question currently before the tribunal is how to go about defining the relevant market in circumstances where a patented drug faces possible imminent generic entry. In defining the market as the market for paroxetine, the CMA focused on the significant price constraints that generic entry presented and found that although other antidepressants did exert some constraints on GSK, they couldn't constrain it from charging higher prices. GSK, on the other hand, argued that no generic entry had occurred, and so it was inappropriate and wrong for the CMA to define the market by reference to the price of generic paroxetine. Instead, they said it should have focused on the non-price competition imposed by the other SSRI antidepressants. Now, in its Servier decision, the Commission has adopted a very, very similar approach to that of the CMA to the question of market definition in relation to another patented drug facing possible generic entry. The appeal in Servier was heard just after the paroxetine appeal, and judgments are pending in both cases. But I want to make a point about process. The CAT held a half-day hot tub session just on this issue, hearing from both the CMA's and GSK's expert economists, asking them probing questions and observing a direct debate between two highly experienced experts on either side of the argument. And its role, the CAT's role, will be to decide the question of market definition for itself in light of all the evidence, including, of course, that evidence of the experts. The case law of the General Court, by contrast, requires it to focus on the process by which the Commission made its assessment. At its most rigorous, and practice varies, the General Court will, when assessing whether there's been a manifest error of assessment, examine the information on the basis of which the assessment was made and the way in which the Commission collected and treated that information, and assess the plausibility of the conclusions the Commission has drawn from it. So the process there is very different in terms of the standard of review applied. Let us consider next the treatment of evidence, and in particular, differences in the weight accorded by the European courts on the one hand and by our domestic courts on the other to different types of evidence. In its judgment in Tesco Stores against the OFT, the Competition Appeal Tribunal considered the probative value of early resolution settlements, pursuant to which 7 addressees of the Statement of Objections had admitted liability for one or more of the infringements ultimately found in the decision. As the tribunal noted, these were essentially corporate admissions. Counsel for the OFT argued that they were clear evidence of the admitting party's involvement in the arrangements that it had found to constitute an infringement of the Chapter 1 prohibition. Counsel for Tesco, on the other hand, argued that no weight at all should be attached to them. The tribunal held that the early resolution agreements, even as regards the conduct and state of mind of the parties which entered into them, must be regarded, and I'm quoting, as having little or no probative value in light of a number of factors. And these factors included, first, that Tesco hadn't had the opportunity to test them through cross-examination, and second, that an undertaking might be led to take a commercial decision to admit liability for an infringement in circumstances where it might not actually be liable, in particular by the prospect of a substantial penalty reduction and the avoidance of potentially protracted proceedings before the competition authority and the courts. The General Court, by contrast, treats corporate admissions of liability as of very great probative value. In JFE against the Commission, the General Court stated at paragraph 211 of its judgment that the Commission correctly points out that statements which run counter to the interests of the declarant must in principle be regarded as particularly reliable evidence. In Intel, the General Court went even further, and it rejected Intel's submission that depositions of actual witnesses with first-hand knowledge were more reliable evidence than a corporate response to a Commission request for information given by their employer. Thus, at paragraph 557 of its judgment, the General Court said, "It's apparent from the case law that responses given on behalf of an undertaking as such carry more weight than that of an employee of the undertaking." That, of course, is very different to what the Competition Appeal Tribunal said in Tesco. The General Court is also generally very sceptical of ex post facto witness evidence. And there are numerous judgments in which the General Court has rejected sworn statements of employees on the basis not only of their content, but also because they are, as a matter of principle, less credible than the documentary evidence relied on by the Commission. And it's routinely the case in General Court judgments that such evidence is simply swept aside by the court with a few dismissive words. Contrast that section of the Tribunal's judgment in Tesco dealing with the Strand 5 hub and spoke information exchange found by the OFT to have taken place as part of the 2003 infringement. The OFT had relied on email exchanges between Mrs. Aldershaw, Tesco's cheese buying manager, and Mr. Michael, the Tesco account manager for McClelland, one of Tesco's suppliers. One such email disclosed Tesco's future prices in respect of a number of cheese lines. The CAT overturned this aspect of the OFT's decision on the basis of the evidence of Mrs. Aldershaw as set out in her witness statement and tested through cross-examination, as it happened, I think, through video link. She was in New Zealand when the trial took place. And her evidence explained the contemporaneous documents and put them in context, explaining, for example, that the retail price for a particular product she had sent to Mr. McClelland was not in fact a future retail price she intended to implement, but a suggested retail price to maintain a percentage margin. So the CAT essentially looked beyond the wording of the contemporaneous documents and allowed that part of the appeal, found that there was no infringement in that respect on the basis of her evidence. It seems highly unlikely, in my view, that the General Court would have reached the same conclusion. Now, whilst the United Kingdom is a member of the EU, these differences that I've sought to identify don't regularly lead to divergent application of competition law in the UK and in the EU. And this is because there are various legal rules and principles in place that aim to secure consistency. Many of these principles have been enacted in Regulation 1 of 2003. Thus, there are cooperation agreements in place between the Commission and national competition authorities such as the CMA, which ensure that suspected anti-competitive conduct is investigated by whichever is the more appropriate authority, and that will usually be the Commission in the case of conduct that affects 3 or more member states. It means in practice that many of the big cases which affect multiple jurisdictions are investigated by the Commission rather than by the CMA, so Google, Intel, the international cartels and so on. Also, Commission decisions finding an infringement of EU competition law are currently binding, of course, in our domestic courts. Further, the duty of sincere cooperation as interpreted by the European Court in Master Foods and as reflected in Regulation 1 of 2003 precludes national courts from taking decisions that conflict with Commission decisions or European Court judgments, or that may conflict with pending decisions. Section 60 of the Competition Act, for its part, imposes a duty on our domestic courts to secure consistency between the principles they apply and the decisions they reach, and the principles applied and decisions reached by the European courts. In addition, there are arrangements allowing for the exchange of confidential information between the Commission and national competition authorities, which allow, amongst other things, for them to take a consistent approach with one another when investigating similar conduct. However, after Brexit, it's likely that at least some of these mechanisms will no longer operate. First, the government's intention is that the Repeal Act will repeal the European Communities Act, which gives direct effect to EU law in the UK. This will mean, of course, that Articles 101 and 102 will cease to have direct effect in the UK after Brexit has taken place. An obvious consequence of that is that where the Commission investigates and takes a decision after Brexit in relation, say, to a global cartel or abuse of dominance case, the scope of that investigation and decision will not extend to the effects of the infringement in the United Kingdom. The CMA will therefore have to take its own enforcement action under the Chapter 1 and Chapter 2 prohibitions of the Competition Act. And this will, of course, lead to more investigations and larger investigations for the CMA at much greater cost. Second, it's likely that Section 60 of the Competition Act will be repealed. Many, including the Brexit Competition Law Working Group's paper of July 2017, propose that Section 60 is replaced with a looser obligation to have regard to the jurisprudence of the European courts, a proposal with which I agree. If adopted, this proposal would nonetheless permit our domestic courts to depart from the EU jurisprudence if they considered it appropriate to do so. Third, the Commission and the CMA will no longer be able to exchange confidential information unless replacement arrangements are put in place as part of the exit deal. The removal of these mechanisms for consistency will mean that the scope for divergent enforcement of competition law in the EU and in the UK inevitably will increase. The differences that I've sought to identify between the EU and UK judicial systems will yield divergent results more frequently. Take a case such as Google or Intel or the trucks cartel. If after Brexit the CMA wishes to tackle the same conduct insofar as it affects the UK market, it would have to open its own investigation. If it doesn't do so, then the conduct in question will continue to be lawful insofar as it's implemented in the UK unless challenged in the courts. Let's assume that the CMA does open its own investigation. Let's also assume that the Brexit arrangements provide for the exchange of confidential information between the Commission and the CMA, which they may or they may not. And let's assume that the Commission and the CMA cooperate and take decisions that are consistent with each other, analysing the facts and the law in the same way, finding an infringement and imposing fines on the undertaking or undertakings concerned. What is clear is that, as I've described, these similar decisions will be subject, if challenged, to very different judicial processes, which may very well lead to different outcomes on appeal. What if the CMA chooses not to investigate? In those circumstances, consumers in the UK who are harmed by the conduct in question and wish to seek compensation couldn't, unlike their counterparts in the EU, bring a follow-on claim. They would have to bring a standalone claim and establish the infringement for themselves in the courts by adducing evidence. The cost and difficulty of doing so will no doubt deter many. It might be thought that the Commission decision, although not binding, would essentially be sufficient. After all, a Commission decision is adopted only after a lengthy and comprehensive investigation, during which the Commission enjoys compulsory evidence-gathering powers. But the ongoing interchange litigation shows us that this isn't so. In its MasterCard decision, the Commission found that MasterCard's EEA multilateral interchange fees, which I'll call MIFs from now on, restricted competition because they set a common level of interchange fee and therefore a de facto floor for the fees charged to retailers. And that decision was upheld on appeal both by the General Court and by the CJEU. In ASDA against MasterCard, a damages claim which sought damages both in respect of the EEA MIFs, which were the subject of the Commission decision, but mainly in respect of domestic MIFs, Mr Justice Popperwell considered the effect of the Commission decision. He quite rightly held that he was bound by the decision insofar as the claim related to EEA MIFs covered by the decision. But in respect of the domestic myth claim, the judge rejected the claimant's argument that he should read across from the Commission decision to reach the same conclusion. On the contrary, Mr. Justice Popplewell held that MasterCard had not infringed Article 101 because in the absence of the myths, the MasterCard arrangements would have collapsed, what he called in his judgment the death spiral argument. There was therefore no restriction of competition. So having heard a trial lasting 22 days and considered evidence from 20 witnesses of fact, 10 of whom were cross-examined, and 2 expert economists, and having had regard to the Commission's findings, the judge reached a diametrically opposed conclusion to that of the European Commission. Mr. Justice Popplewell also reached a different conclusion to the Competition Appeal Tribunal, which had a few months previously heard the Sainsbury claim against MasterCard. The CAT concluded that there was a restriction of competition based on its finding that the appropriate counterfactual was ex-ante bilateral arrangements between the issuing and acquiring banks. Although the claimants in the Asda case amended their case so as to include such a counterfactual, ultimately they didn't actually pursue it at the hearing before Mr. Justice Popplewell, and the judge in Asda found on the basis of the different evidence and arguments before him that this wasn't a realistic counterfactual, and so on that basis he reached a different conclusion to that of the Competition Appeal Tribunal. Now matters don't end there because of course Sainsbury's action against Visa, whose interchange arrangements one might think operate in a similar way to those of MasterCard, was heard by Mr. Justice Phillips earlier this year, and judgment will presumably be handed down fairly soon. In that case, Visa argued that there was no restriction of competition, but the argument they advanced was different to that that was advanced in the case before Mr. Justice Popplewell and accepted by Mr. Justice Popplewell. So, as well as demonstrating the central proposition of this lecture that our different domestic judicial procedure is liable to produce different outcomes, the interchange litigation also highlights another fundamental feature of our judicial process. Its adversarial nature, both in the context of a standalone claim, but also in the context of an appeal against a CMA decision, and the great weight given by the courts to witness evidence, means that outcomes are liable to differ depending on what arguments a legal team happens to advance, what witnesses they choose to call, and how impressive the particular witnesses are. Now let's imagine a cartel case post-Brexit. The Commission has carried out a lengthy investigation and reached a decision, say, in relation to finding a global price-fixing cartel. Consumers in the UK bring a standalone claim and seek to persuade the court that it should read across from the Commission decision. The defendants, on the other hand, argue that whilst the court can take account of the Commission decision, assuming that Section 60 is amended in the way that people are advocating, the court must make up its own mind on the basis of the evidence before it. The defendants call witnesses who give their own account of events over the relevant period and say that they were unaware of any price-fixing arrangements. On the contrary, they say they competed vigorously against the other defendants for business. Those witnesses press on the court alternative explanations for the incriminating documents relied on by the claimants. Now, those explanations might appear to be convincing, but is this really a more reliable way of assessing the truth of events that took place many years and often many decades ago? The main protagonist may have retired or moved on and not be available to the defendants. The defendants aren't compelled to call any particular witness. It's open to them to choose not to call employees that they think might be unhelpful, although of course in certain limited respects adverse inferences might be drawn. But even if all the appropriate witnesses are available and are called, the memories of long ago meetings and communications are likely to be fallible, as indeed Mr. Justice Leggett so convincingly explained in Guessman. It's interesting in this context to go back to what the Court of Appeal said in Crean about these issues. At paragraph 76 of its judgment, it said this: "We are left profoundly uneasy by the judge's approach to the evidence. It's apparent from what the ECJ said in Delimitis that a comprehensive investigation and evaluation of a complex economic situation needs to be conducted before it can be determined whether or not Delimitis Condition 1 is or is not satisfied. The judge rightly acknowledged that he couldn't possibly embark on a detailed research investigation himself, and that to do so would be inconsistent with the role of a judge in civil litigation in this jurisdiction. That is why such investigations have been entrusted to bodies such as the Commission, the MMC or Competition Commission and the OFT. The conclusions reached by such bodies involve assessments of matters on which experts can reasonably differ. For an English judge trained in the adversarial system, the impression made by a good witness is very likely to outweigh the evidence contained in a document to which no witness before the judge can speak with direct knowledge. Mr. Belianovsky, for example, couldn't speak for the Commission in respect of the Whitbread decision. He was never a party to the Commission's reasoning, nor aware of the full range of the material which it had, apart from what was revealed in the decision. Much material which it receives is commercially sensitive and confidential. It's apparent that Mr. Crean was frustrated in the attempts which he made to obtain evidence by the issue of witness summonses. The result is that a judge embarking on the exercise which Mr. Justice Park did perforce makes his assessment on the evidence which the parties choose or are able to put before him, and inevitably does so on material less comprehensive and contemporaneous than that which was available to the Commission carrying out its own exhaustive investigation years earlier. Now, in concluding and drawing these themes together, after Brexit, once the mechanisms for consistency have gone, the inherent and profound differences in our judicial procedure and that of the European courts will, in my view, become much more liable to lead to divergent outcomes in the enforcement of EU and UK competition law. That might be said to be an unsatisfactory state of affairs for businesses operating in a global marketplace, selling their goods and providing their services across the borders of European countries. What does this mean for the CMA? In my view, it means that when carrying out parallel investigations with the Commission into big antitrust cases, the CMA will need to bear in mind these differences in judicial process that I've sought to highlight. As compared with the Commission, challenges to its decisions will be lengthier, costlier, involve a more intensive review and focus on evidence of witnesses, both factual and expert, which will be tested through cross-examination, and therefore the process will be less certain for it. In my view, this means that the CMA's approach to investigating conduct, to carrying out its investigations, may have to differ to that of the Commission, even where they're investigating the same conduct. Unlike the Commission, the CMA will not be able to confine its investigation to an analysis of the documents, safe in the knowledge that the review carried out on appeal would take the form of a review of its analysis of the documents. Given that the Competition Appeal Tribunal will focus on witnesses, the CMA may have to make its investigation more witness-focused so that it can, during the administrative phase, take into account the recollection of events of the individuals concerned. This means that the burden on the CMA is likely to be greater than that on the Commission, both at the investigation and the appeal stage. Now, what, if anything, should be done about that? Now, on the one hand, it is of course essential that decisions of the CMA are open to proper challenge. On the other hand, it's important that the CMA can operate efficiently and effectively. How this will play out in practice for the CMA may not become clear for several years after Brexit. And if changes do need to be made, what should they be? Should we move to a judicial review system like in Luxembourg? Should we move to a prosecutorial system like in the United States? Should the Competition Appeal Tribunal adopt a new evidential approach to competition cases based more on the EU approach? Might our judges develop procedures for managing these cases which pay deference to the investigation carried out by the regulator and give greater probative weight to contemporaneous documentary material than to witness evidence, perhaps by applying as a matter of course the conclusions of Mr. Justice Leggett, to which I've referred? And if these changes do take place in the context of competition litigation, might they spill over to commercial litigation more generally? In other words, might our procedures become a little bit more similar to those in Luxembourg? If they do, this would be a paradoxical result of Brexit. I won't attempt to provide answers tonight to these very difficult questions which will arise in the UK in the field of competition law, but at least I have, I hope, identified some of the difficult questions, particularly the procedural and evidential questions, which are likely to arise post-Brexit. It only remains now, David, for me to take you to the Horse and Groom pub in Marylebone to see if we can find young Pavel Pavlovsky. Thank you all very much.
Well, obviously that was fantastic, so thank you so much to Marie for doing that. I have only two things to do. One is, importantly, to invite you for a drink afterwards, and also to say, David, we already have a speaker for next year.
We've got a speaker for next year, with Ian Forrester from the General Court, and he's speaking on the 6th of November in Liverpool. And so because he's a venture of the Liverpool, so he's very keen to do it there. And we're looking forward very much to that. But I would like also to add my thanks, firstly to River Chance for doing this together with Brick Court, and secondly to Marie for this wonderful speech she's just given. Everything, the CVs of hers said are correct, as you did. I've heard. Thank you very much indeed.